Ladies and gentlemen, please welcome our next panel.
Okay, thanks very much, everyone. I'm delighted that you all could join us today. Our panel, as you know, is called Hot Button Enforcement Issues. Is a sea change afoot? And this is one of the kind of standard panels that we have at the conference every year, and is at least a highlight for me, and I think for those of us who do enforcement work, because we're really privileged to have with us the senior enforcement government lawyers from all of the agencies that the people in this room care about. And not to be outdone by that, we also have a senior enforcement lawyer from the industry side who I'm sure can hold her own against everyone else at the table. Because we only have a 50-minute session today, I'm not going to give these fine lawyers the introductions they deserve, but instead invite you to take a look at their bios, which are included in your materials, and instead just have each of us go down the table and say who we are and the entity with which we're associated, and we'll take it from there. I'm Jean Vita, now senior counsel, hard to believe, formerly a partner before I hit that farming age of 65, at Covington & Burling in Washington, and basically spend my entire practice doing regulatory compliance and enforcement work for financial institutions. Rich?
I'm Rich Ashton, the Deputy General Counsel of the Federal Reserve Board. Enforcement is one of my responsibilities at the agency.
And I'm Monica Freas, Director of Enforcement.
Mike Grady, I'm the Acting Deputy Chief of the Bank Integrity Unit in the Criminal Division of the U.S. Department of Justice.
Good morning, Maylin Kwanget. I'm the Head of Litigation and Regulatory Investigations at Citigroup.
And so I'm Kara Peterson, the Principal of Deputy Enforcement Director at the Consumer Financial Protection Bureau.
Okay. So again, in the interest of time, we're going to dispense with the introductory remarks and jump right into the questions. And let's start off with something that I know a number of us care about, and that is consumer protection and fair lending. And as we all know, in March of this year, the CFPB announced that it would be looking at alleged discrimination as a violation not only of the fair lending laws, but also of the unfairness provision of UDEP. In particular, the Bureau said discrimination can be unfair in cases where the conduct may also be covered by a COA, as well as in instances where a COA does not apply. So Kara, let's break this apart and first deal with the statement, discrimination can be unfair in cases where the conduct may also be covered by a COA. Given the fact that we already have the Equal Credit Opportunity Act and the Fair Housing Act, and that both seem to be quite robust tools to deal with lending discrimination issues, what is the public benefit of also sanctioning the conduct under UDEP? And candidly, isn't this really just piling on?
Well, thanks, Jean, for the question, and thanks for the opportunity to be on this panel. I need to start by reminding folks, as an initial matter, that the views I'm going to express today are my own and not necessarily those of the CFPB. So on this topic, as you and others know, the ECOA and CFPA are two separate laws the Bureau enforces and supervises for. And as we put forth in our exam manual, we explained that we're going to be looking at fact patterns to determine whether potential discriminatory conduct could be unfair. What that means is we're looking to see whether discrimination between different groups that we might observe would cause substantial injury to consumers, that injury would be reasonably avoidable and not be outweighed by countervailing benefits to consumers or competition. And so, for example, to make kind of a concrete example of that, you might observe, someone who is able to open a deposit account or a receive service to cash a check on the basis of their race, and that kind of conduct might cause substantial injury that the consumer can't avoid and wouldn't be outweighed by any countervailing benefits to consumers or competition. So to specifically answer your question, no, I don't think this is piling on. I think what it means is we're considering all the tools and all the authorities that we enforce and supervise for to try to root out discrimination in the consumer finance market, which is an important priority and responsibility that the CFPB has.
Okay, so I appreciate that, and I get the point, and we'll get to that in a minute, about the example you gave where a consumer tries to open a deposit account. But in the first piece, as I understood the Bureau's statement, it wasn't just focusing on those areas of discrimination that aren't covered by the fair lending laws, but also included conduct that would be actionable under ACOA. So why double charge it under UDEP?
So,
Or maybe is it that the Bureau sometimes will bring it under ACOA and sometimes under UDEP?
I mean, we're going to be considering the facts and the circumstances. In other areas besides this one, we sometimes, double charge something, have alternative theories of liability, depending on what our goals are in the case or the facts that we're presented with. And the same would go here. We would consider whether to bring an unfairness claim, but we wouldn't necessarily always bring an unfairness claim for OCC.
And then the other part of the sentence that referred to the conduct that doesn't involve lending, for example, opening a deposit account. And I can certainly understand, and I think those of us in the room can understand the public policy reason behind that. However, as a practical matter, given that you're not going to have the HMDA data that lets you determine race, for example, in lending products, how is the Bureau going to figure out whether you've got a pattern of practice of discrimination that involves a group or a cohort of consumers who would be in a protected class on the basis of race?
Well, just to start, you're right that the CFPA is broader and applies not just to credit, but also other non-credit consumer financial products and services. So that might be deposit accounts, cashing the check, remittances, collection, servicing, and so on. And the CFPA does not have a specific list of prohibited bases laid out in it, but it does provide a statutory test that will be applied to determine whether there's been an unfair practice. And how we do that would be the same, sort of tools we use in any of our investigations. It might involve data, it might involve whistleblowers, it might be consumer complaints about an issue. We may, come across other internal or external information to put together a matter where we have evidence to support that type of claim.
Okay, thanks. So Monica and Rich, for your respective agencies, turning back to the prong where you each have jurisdiction, mainly under the fair lending laws, what's the view of your respective agencies in terms of the need or advisability of also charging this conduct under UDEP?
Well, I'll start, and I'll just say I think we agree with the idea that depending on the facts and circumstances, you could have a case where discriminatory practices may meet the criteria for unfairness under UDEP. But whether we are going to cite a UDEP on top of a ECOA or Fair Housing Act violation that we've established, I don't see us sort of as a matter of course always looking to see whether we have a basis for UDEP. But at bottom, we're not looking to sort of use every tool in our toolbox, but our goal is always to, rectify the fair lending compliance risk management issues and deficiencies and eliminate discriminatory practices and impacts to borrowers. And so to that end, I think we will rely, as we always do, on the legal basis that best fits the facts and circumstances that are in front of us.
Rich, what about the Fed?
Yeah, so I think for the Fed, we really haven't taken a position officially on this particular issue. I mean, we do enforce the fair lending laws like the other banking agencies and refer them to justice where we think there's a pattern of practice. So I think we will continue to do that, and to be seen whether or not we will sort of interpret UDEP in a way that is consistent with what the Bureau has been doing.
Okay. So let's turn more specifically to fair lending. And we're all aware that in October of 2021, the Attorney General Merrick Garland held a press event where he announced a new initiative combating redlining. And the event was attended both by the acting comptroller and also by the director of the CFPB. And the two banks that were cited as part of this press event each had entered into consent orders that involved a fair lending issue in one single market. In the case of Cadence Bank, it was Houston, and in the case of Trustmark, it was Memphis. So the question is, and we also know that the bank regulators have been keenly focused on this issue, and some of us know that the Department of Justice on its own is conducting fair lending inquiries without waiting for a referral from the bank regulators. And when you think about the banks that are in this room, I think it's fair to say that a number of institutions, if nothing else, just given the sheer size, are going to be faced with a situation where there's going to be some single market out there where, lo and behold, the HMDA analyses show that they are performing they're performing below peer to a statistically significant extent. And so the question is, Monica, for example, how is the OCC planning to handle these situations? And is it reasonable to hold banks to a standard where if there's one market where you're below peers, that you're opening yourself up to a fair lending action?
Sure. So I think maybe everyone doesn't know, but our exam focal points are risk-based. So when we're looking to determine what is the focus of a fair lending exam, we're looking at a lot of different data points. We're looking at HMDA data. We're looking at information that's gathered as part of the supervisory process, including our fair lending risk assessment tool that we conduct at every bank during each exam cycle. And as part of this process, we're always going to look to whether the proportion of a bank's mortgage application and originations in majority non-white census tracts is going to be comparable to their peers. And if a proportion of a bank's lending activity is less than peers to a statistically significant degree, this may be indicative of redlining, and we will likely look deeper into those areas. But I think it's really important in this area to stress that we're not looking at one instance of a statistically significant disparity. We're looking at performance relative to various sets of peers across multiple years to assess trends in the data. And I think it's also critically important to note that the statistic elements of redlining is just one aspect of the factors that we look to. And a lot of these factors were important in the very cases you cited in Trustmark and Cadence, and that had to do with where were their branches located, what was the location of their delivery channels, and in particular brokers, and in those cases, loan officers. We also look to CRA assessment areas and to see whether they reflect any discriminatory inclusions, and then obviously we're always looking for explicit or overt evidence, which thankfully we find that more rarely. And then lastly, we're always going to consider the bank's points in response of whether they can sort of cite non-discriminatory reasons for the patterns that we're seeing in their origination and applications data. And so it's only after all of those factors, not just the statistics, are considered that are we able to determine whether we would refer that matter to the Department of Justice or cite the actual Fair Housing Act violation or a CO violation. And I would also note the standard for referral is a lower standard in the sense that we don't actually have to find a violation. We have to find the potential for a pattern of violations. So in answer to your question, if a bank has a presence in an individual market where the lending performance in a majority-minority census tract is below peers to a statistically significant degree, and it's it's a pattern of lending that spans over years, and yes, the bank should have heightened concerns, and the bank should be looking closely at all of the other factors and how they're, how they sort of set in each of those factors. So I know that's a lot. I mean, fair lending is a very complex area. And I would just wanted to mention something practical. There is a fair lending webinar that is available on the Fed's website, and it is excellent. It's a 90-minute presentation. All of the federal agencies are represented. It's DOJ, HUD, OCC, CFPB, FDIC, NCONA, and they talk about all of these various factors and really go into some very practical examples and advice. And so I commend that to you. You just need to search for Outlook Live, Federal Reserve, or Outlook Live, FRB. It's one of the first it's one of the first archive webinars that'll come up. But I think anyone who works in this space, I would highly recommend it.
Okay, thanks. Mei-Lin, what are your suggestions coming from the banking side about what a large institution can do to manage this kind of risk?
Yeah, thanks, Jean. So obviously fair lending is a top priority for Citi. I'm sure it is for every large bank. And robust monitoring and training is sort of the first line. We make sure that that's happening at the first and second lines of defense. We want to make sure that everybody focuses on treatment that doesn't regard demographics at all, and that goes from inception through pricing, marketing, servicing, et cetera. And then another thing we look at is obviously more and more banking transactions are taking place online, and as that happens, sometimes that can lead to physical branch closures. And so looking, where those branches are, what determination, what can we think about when we're thinking about our branch footprint. When we're staffing our branches and our call centers, we think about what languages we need to have equipped there and serve the communities properly. We consider outreach to historically disadvantaged communities and diverse communities, and this can be further facilitated through partnerships with focused agencies and community groups. We want to think about marketing that resonates with the applicable community, including diverse portrayals of customers is very important, and we take proactive steps, to market to targeted areas and make sure that it's done in a manner that's inclusive and non-discriminatory. And then one thing that's definitely worth mentioning is close attention to the use of models, including any machine learning or artificial intelligence, to make sure that there's not potential bias built into those models or any disparate impact that it may be creating, and considering the use of alternative data in a way to assist and expand access to credit and to financial products. So we take make similar efforts and pay similar attention to activities outsourced to third parties or done in collaboration with others. And then finally, I'll last mention that it may be necessary to consider implementing a special purpose credit program to get traction in particular areas.
Okay. So if I were to summarize what both Monica and Mei-Lin covered, it's one, jump on the issue when it's small, taking a wait and see attitude. These things rarely get better on their own. Second, physical presence really does matter, notwithstanding the fact that everybody's moving more toward digital connections, that having a branch or an LPO in these communities remains important. Third, having effective marketing to the targeted communities. Fourth, and perhaps most important, making sure that you're offering the lending products that are going to be attractive to those communities, so that you can bring in those applications into your institution. And finally, what I think was kind of implicit in both what Monica was saying and Mei-Lin is stay close to your regulator on this issue. And the more transparent and the more there can be a dialogue between the institution and the regulator, that often can help move the ball forward. But now let's see if we can, shift the focus and talk about anti-money laundering for a few minutes. And as we all know, when it comes to the Department of Justice, it used to be unheard of that an institution like any of those in this audience would ever be charged criminally, certainly on an AML offense. But as we also know, times have changed. And that when it comes to banks, including those that are similar to those in this room, do face potential exposure. So for Mike, I'd like to ask the question about what are the department's priorities when it comes to banks? And by banks, I mean banks like those who are in this room. I'm not talking about some kind of fly-by-night operations.
Thanks, Jean. And I want to start by giving the usual disclaimer that the views I express today are my own and not necessarily those of the department. There's a lot going on at the department with respect to corporate enforcement, which is applicable to banks. The department's top priority when it comes to corporate enforcement is and remains to ensure that individuals are held accountable for their own wrongdoing. And the most important development on that front is that the Deputy Attorney General has announced that we are returning to the prior policy that corporate entities can only receive cooperation credit if they provide all available information and evidence pertaining to all individuals who were involved in wrongdoing and not just those that the entity deems to have been substantially involved in the wrongdoing. And I expect we'll circle back on this point. Second is sanctions. The Attorney General, to paraphrase him, has said that we will leave no stone unturned in the investigation, arrest, and prosecution of those who engage in criminal wrongdoing in support of Russia's unjust war in Ukraine. Along this front, the department has stood up its Klepto Capture Task Force, which is being led out of the DAG's office, and it's a collaboration of the Money Laundering and Asset Recovery Section as well as the National Security Division. I think that in addition to Russian sanctions, that we remain to be very focused on continuing to enforce sanctions against North Korea, Iran, and other countries as well. And the third highlight that I would like to cover is virtual currency. We remain very focused on prosecuting thefts, fraud schemes, and other criminal conspiracies involving virtual currency. To that end, about almost a year ago at this point, we've stood up our National Cryptocurrency Enforcement Team, which is charged with leading and coordinating our efforts on this front.
Okay, so thanks. And let's return to your point about sanctions. And we all know that there are foreign actors out there who try morning, noon, and night to avoid sanctions and penetrate the U.S. Financial system. And we also know that the institutions like those who are present here have robust compliance programs in place and lots of tools, automated as well as dedicating human resources to try to keep those foreign actors from avoiding the sanctions. But sometimes they succeed. And the issue is, when they succeed, it's not always just the foreign actor who the department seeks to pursue, but sometimes the institution. And so the question to you is it really fair to go after institutions when the sanctions are avoided and the institutions are really trying to keep those foreign actors out of their banks?
That is a great question. In most of my sanctions work, the financial institutions are our partner. I've told many banks this, that we could not do what we do in these types of cases without their assistance and their help. And we genuinely appreciate the help that we receive, whether it's responding to subpoenas, providing SARs. That cooperation is frankly essential. What is also true, though, is that in these types of sophisticated financial crimes, these sanctions evasion cases, the wrongdoers also could not do what they're doing without financial facilitators, whether it is setting up accounts, whether it is drafting fake contracts to justify wire transfers, or whether it's executing those wire transfers. They also need help. And we're cognizant of that. And so the advice that I would give to the industry on this front is on the correspondent banking front, make sure that your KYC is up to date. Make sure that you understand whether or not your correspondent banking customers have adequate programs in place. Make sure you understand whether they are sending transactions through for other foreign financial institutions. On the private banking space, I think the messaging is critically important, that the institution will provide no quarter for relationship managers who will try to move and hide assets for customers. On that front, I think this is pretty basic, but just make sure that you are implementing your standard rules, whether it is your KYC rules before setting up an account or opening a new account, or whether it is closing committee rules. Make sure that you're referring people as expected. There are sort of two scenarios I expect to see on this front. The first is banks, correspondent banks, that they find an issue, whether it is a transaction going through for a designated individual, or whether it's a customer has an inadequate program, or they're sending transactions through for another financial institution, and the bank tells their customer, you need to stop this. Customer doesn't stop it. They get another chance, they don't stop it. At that point, the customer is told, okay, you need to find a new banking relationship. You've got 90 days to do it. They don't do it, they get an extension of time. And pretty soon, a year has passed, and they're before us at the Department of Justice. The transactions going through the bank are for a designated entity, and that's the point that I'm hoping that we can avoid. On the private banking front, the scenario I fully expect to see is that a relationship manager will circumvent the bank's internal rules, get a supervisor to sign off on opening an account for the benefit of a sanctioned individual without doing the necessary KYC or the necessary checking. And at that point, the bank is going to end up before us arguing, well, we didn't know, what this RM was doing, and our response will be, but you also didn't follow your own internal rules with respect to the opening of the account or the closing of the account. And last, my last point on this is that if you do find an issue, I really strongly encourage you to come in early. It will help us in the investigation of that conduct and hopefully minimize any ill effects, but also it's going to maximize the potential cooperation credit that your institution can get in the event there is any kind of wrongdoing within your institution.
Okay, and actually your last statement may kind of set up my next question, which is, how is it that the department decides when it's going to intervene and when it's going to let either the bank regulators or FinCEN take care of the issue?
So we really go by the book on this, and the book for us is the Justice Manual. And so there are principles of federal prosecution that say that if we believe that an offense occurred and we believe that the evidence is going to be sufficient to prosecute it, we should do that. We will also consider, however, whether there are alternatives to prosecution that will adequately suit our goals. This is also set out in the federal principles of prosecution of business organizations, which is a set of 11 factors that we consider when deciding whether to prosecute a corporate entity. And one of those is whether alternatives exist that will meet our goals. I do think, however, that our primary consideration is the facts of the case and whether an offense happened, whether the evidence is going to be sufficient to prove our case. And if it's a close call, if there's really a potential for that this was rogue actors, that the compliance program functioned as it should have, at that point, I think that's where we would really strongly consider deferring to our colleagues for a non-criminal resolution. And that said, we often do, even in criminal resolutions, we're often working in parallel with our colleagues at other offices.
Right, we don't see that as necessarily a win-win.
No.
We prefer kind of one enforcement action and let have you leave it to your colleagues at the regulators. But okay, let's shift gears again. And we've heard a lot at the conference about the relationship between banks and fintechs. And as we all know, these fintechs tend to be quite entrepreneurial. They typically are targeting underserved populations, which can create compliance issues on all sorts of different fronts. So for starting with Monica and Rich, I'm going to offer a hypothetical. And let's assume that the bank has a relationship with a fintech that's quite entrepreneurial. The bank does appropriate due diligence before bringing on the fintech partner. The bank has a sophisticated monitoring program to monitor the fintech's pricing and marketing practices. And the bank has the fintech certify periodically that it's in compliance with the law. And nevertheless, what happens is the fintech offers a promotion, but it does so behind its login screen, so that the activity isn't picked up automatically by the financial institution in its monitoring of the fintech. And the way the bank finds out about it is either through customer complaints, or they get a knock on the door from the regulator. And in my hypothetical, the regulator is focused not only on the fintech, but also on the institution. So my question to each of you, and Rich, maybe start with you, how are these situations handled at the Fed? And wouldn't it be more fair to go after the fintech, which is really kind of the stepping over the line, rather than the financial institution which has the compliance program in place?
So I think basically sort of starting with the general principles, this is an area where we're spending a fair amount of time looking at this relationship. The enforcement authority of the regulators really depends on whether the fintech, in your hypothetical, meets the definition of institution-affiliated party. And in a lot of these cases, the fintech company is serving as the agent of the bank. Typically, the fintech will have some arrangement with the bank that is offering banking as a service, where the fintech can solicit deposits that are then put at the bank. So in a sense, the fintech is acting as the agent of the bank, which brings it within the jurisdiction, enforcement jurisdiction of the banking regulators. And so the extent to which the responsibility for misconduct is allocated between the fintech and the bank, which is sort of the heart of your hypothetical, I think would depend on the facts of the case. Normally, under general principles of agency, the principal would be responsible for what the agent does. But in a situation where the principal has exercised due diligence and done the best to try to figure out what's going on with its agent, I think that's a situation that we would just have to look at depending on the circumstances. I mean, whether there's strict liability, I don't know that that's a question that we can answer at this point. Obviously, the better the due diligence by the bank over the agent, the better off the bank is going to be. I think in the one case that the Fed did bring back in 2015, where we did bring an action against the partner, the bank partner, who had engaged in unfair and deceptive practices involving a deposit that was housed at a bank. We did require restitution and a penalty against the fintech company, but we also brought an action against the banks. And because in that case, at least, we believe that the bank's oversight of the fintech partner was inadequate. So I think the answer to your question is it's not something we've really had to deal with just yet, but it would depend on the facts.
Okay, so is it fair to say, I mean, could you conceive of a situation where the Fed just goes after the fintech as an IAP and doesn't go after the institution?
I think, yeah, it's potentially possible. It would depend on the circumstances.
Okay. Monica, how about the OCC?
So I think the OCC's focus, and I think sort of the jurisdictional question is actually, I think maybe it's a harder question than maybe it's seeming here, but I think, you know, we obviously look at the jurisdictional question, but I think our focus is really on consumers. And if there are consumers harmed as part of this process, and we are able to address those consumers through an action, and we have, you know, a clear path, I think, you know, our aim is always going to be to make sure that the consumers are made whole and that the practice that's harming consumers is stopped and that there are controls in place to prevent future harm to consumers. So I think it's sort of when, you know, we're looking at whether or not we take an enforcement action against the bank, it's all of the factors that you talked about, the risk assessment on the front end, the due diligence and the monitoring. And you talked about, in this case, you know, a complaint coming through, but if you don't have a window into the types of complaints and you're, again, sort of waiting until it reaches to a systemic level or violations of law or where consumers are harmed, you know, we're going to be looking at that. And so it's very fact specific in terms of which cases we would bring actions in, even with respect to the bank. But I think if there are harmed consumers, we are certainly going to be looking either, you know, risk of harm to consumers and harmed consumers. We're going to be looking at the big picture about whether or not there's a means to make consumers whole.
Okay, thanks. Mei-Lin, do you have any suggestions on how large banks should address this compliance risk involving an overly enthusiastic fintech, shall we say?
Sure. So the industry is very focused on the proposed interagency guidance in this area, not just the body of the draft guidance, but also the restated Q&As that the OCC has out there. So let me just run through those factors quickly because they are very helpful in thinking about fintechs. So first, planning. Before you enter into any third-party relationship, develop a plan that outlines the inherent risks of the activity of that fintech third party, determine how the arrangement aligns with your bank, and understand how the bank's organization will identify, assess, select, and oversee that party. Second is due diligence, which we've talked about before. Of course, we need to perform proper due diligence to assess whether that fintech is actually capable of doing the activity that's expected of it and will adhere to the banking organization's policies. Third is contract negotiations. So in the course of negotiating that written contract, make sure you articulate the rights and responsibilities of all of the parties. Fourth is oversight. Enable the board of directors and the management to oversee the relationship. Fifth, of course, is the ongoing monitoring. So you have a process to, in real time, monitor the fintech's activities and performance. And sixth, probably appropriately, is termination, to make sure that there are contingency plans for terminating the relationship in an effective manner if you need to.
Okay, thanks. I think one of the challenges that we've all faced is that this is such a rapidly evolving area. And so it's an area where regulation by enforcement seems to be particularly challenging because I think there's a fair amount of uncertainty in the industry about what the expectations of the regulators really are. And Mei-Lin made reference to the interagency guidelines, which are helpful, but it would be even more helpful if the regulators could define more clearly what the expectations are in terms of the relationship between the institution and the fintech. So Rich, my question to you is, if the regulators want to refine their expectations in terms of what they want the banks to do, wouldn't it be better to do this through regulatory guidance or regulations rather than through enforcement?
Well, I think, this is still an evolving area, and I think what exactly the regulators' expectations are is something that's still being worked out. So probably trying to figure out, what the best way to get those expectations communicated it's something that we're still working on. So I think it's probably too early to tell how we're going to handle it.
Okay. Let's move on to another topic which Mike alluded to at the beginning of the program, and that is individual liability. And in addition to the speech that was given by the Deputy Attorney General, Lisa Monaco, where she emphasized the importance of individual accountability and companies providing the department with all non-privileged information about individuals involved in order to get full cooperation credit. We've also seen the other enforcement agencies focusing more on individuals. For example, in 2020, FinCEN fined the former chief risk officer of US Bank for failing to prevent BSA violations. And Monica, we all know the OCC has been quite active in this area, including bringing suit against former senior executives at Wells Fargo. But again, to take the position of the industry, especially for these large institutions, is it really fair to tag an individual, and certainly criminally, but even civilly, with liability? Because when you think about it, it's rare that a single individual is making a decision. Either the person is junior and people more senior are telling the person what to do, or it's a senior person who can't know everything and is relying on the information being brought to him or her by subordinates. And often, frankly, in these institutions, it's not just a single individual or the person in this office is compared to this office is compared to another office, but rather people sitting together as a committee in kind of an entire structure of committees making these decisions. So, Mike, what is the department's thinking behind this issue of individual liability?
Thanks, Jean. I think you outlined neatly why these are difficult cases to make, but nonetheless, sort of where we are able to prove that an individual acted in the BSA context willfully, we definitely believe it is fair and appropriate to bring individual enforcement actions. And in a corporate context, if there's a case against a company, that is always going to be premised on the conduct of individual employees. Companies act through individuals, and legally speaking, in order to build that case against the company, we're going to argue that certain individuals engaged in certain conduct that was within the scope of their duties and responsibilities and in furtherance or for the benefit of the company, and therefore the company is vicariously liable. So if we're bringing a corporate enforcement action, there really should be individuals who we believe are responsible for that wrongdoing. And in terms of the fairness issue and why the department believes that this is so important, I'll just throw three reasons out there. One is deterrence, that the department very much believes that the best way to deter corporate wrongdoing is through the prosecution of individuals as opposed to simply entering into agreements with companies. The second is, and it's related, is it structures the incentives, I think, most appropriately for the companies to actually put in place the compliance programs needed to stop any kind of wrongdoing. And the third is a fairness issue, and I think this is probably the most important, that in all contexts, all criminal justice contexts, we prosecute individuals. And if for some reason, if there is a different standard, or if there is perceived to be a different standard in the white-collar context, it is, as the Attorney General has said, going to sort of call into question the rule of law and whether we are acting fairly as prosecutors or employing a double standard for certain types of defendants.
Okay, thanks. Monica, tell us the OCC's perspective on this.
So I think it's fair to say in general, we think it's important and it's a priority of ours to hold individuals accountable where both the facts and the law support an enforcement action and that action meets our supervisory objectives. But to address your specific point about fairness, we don't bring cases based on the seat the individual occupies or the titles that they hold. We, in each case, carefully consider evidence of how that specific individual, specific conduct caused or brought about the violations, breaches, or unsafe and unsound practices. And I think the Wells Fargo case is important, and I can't speak about the facts of that case. It's in ongoing litigation, but I think we can all generally acknowledge that that case is important because it's going to be one of the first ones that's actually going to speak to the duties and responsibilities of those senior officers in the second and third lines of defense. And the hearing in that case, just to give you a status update, it concluded in January, so live testimony was completed. We spent the entire summer briefing the issues. It is now pending before the administrative law judge, and he has indicated that he will issue a decision by November 30. So we'll all be watching for that unless he changes his dates. But I think it's important, when those cases come out and the decisions are out, that you don't just read the press headlines. I think if, go to read the actual decision. I think if you go and actually the ALJs do a very good job of sort of detailing all the evidence in terms of what we put forth and what respondents put forth. And so when those decisions come out, I urge you all to actually read the detail behind the decision. I think if you take, spend some time in those cases, I think you would understand much more clearly why we took the specific action in that specific case against that specific individual.
Okay, thanks. Mei-Lin, hearing this, and again, with all of us reading about these enforcement actions against individuals, to what extent has that affected banks' abilities to attract senior people to kind of more high-risk positions?
So I think it's had a pretty measurable impact. It's worth pointing out that outside the U.S., this trend toward individual accountability has really taken force in very specific frameworks. In the UK, we have the senior manager regime. In Hong Kong, there's a manager in charge regime. In Australia, the banking executive accountability regime, just to mention a few. And these are all like 5, 6, 7 years old. So we're seeing it worldwide, and then in the US, as we've noted from our regulators here, it's become more and more common every time there is a corporate resolution for there also to be an individual named. And I'll say all of these things together are definitely affecting hiring, promotion, and retention within senior levels in the banks.
Okay. And turning to our final topic of recidivism, which again, the Justice Department has focused on, but in particular, the director of the CFPB has been quite outspoken on this topic. But Kara, given how large and complex these institutions are, and recognizing that because they're so big, things are going to happen, and so there will be violations. But often the violations occur in different areas of the bank or involving different products. And so isn't it more appropriate simply to sanction the institution for the conduct that's at issue? Why should there be an enhancement simply because there was another violation that preceded this one?
Just a little background. One of the things in particular that Director Chopra has spoken about in this space is the consequences of repeat offenses, particularly at large institutions. When you compare it to small institutions, consequences can seem lesser, and that it's got a concern that recidivism, corporate recidivism, could just become a cost of doing business. And so, what we're focused on is ensuring that serial violations of the law, that harms consumers doesn't just become the status quo and a cost of doing business. So one of the things we're doing at the Bureau is we've created dedicated units in both enforcement and supervision focused on the detection of repeat offenses and corporate recidivism, and thinking about new ways and just efficient and effective ways of holding folks accountable so that this sort of recidivism, doesn't just continue. And so, sort of my advice is to really scrutinize the orders that you're under and take them seriously. The idea that they're just suggestions or that they aren't to be taken seriously is something we really want to make sure we stamp out. But as to your question about like whether this is fair, when we're deciding whether to bring an action, the form of that action, the type of penalty, the type of remedies, we are always taking into account the facts and circumstances, and that's not going to change. But I do think it's more than fair to consider whether there have been serial violations, whether the institution has sort of fallen down on the job for consumers previously when we're considering what the appropriate next steps are in a particular action.
Okay. And with that, we are unfortunately out of time, but in particular, I very much want to thank not only Mei-Lin, but also, in particular, these lawyers from the government enforcement agencies. They're incredibly good sports to put up with these questions that may not always have been framed in the most objective of ways. And I really appreciate your indulging me on that, and it's really important for us to hear from you. So thank you very much.
Thank you.
Thank you all.